Okay.
A very warm good evening to all of you. പൂക്കളില്ലാതെ പുലരിയില്ലാതെ ആർദ്രമേതോ വിളിക്കു പിന്നിലായി പാട്ടുമൂളി ഞാൻ പോകവേ നിങ്ങൾ കേട്ടു നിന്നുവോ തോഴരെ നന്ദി നന്ദി. Sugathakumari, the eminent Malayalam poet, conservationist and women's activist, fondly called Sugatha teacher by hundreds of her admirers and followers, passed away. One of the most celebrated Malayalam poets of the contemporary era, Sugathakumari teacher was known for her unique poems filled with compassion and philosophical quest. Always a constant supporter and solace for destitute women, she had been running Abhaya, an organization for the deprived women, including rape survivors, domestic violence victims, and drug addicts, for over 3 decades. In 2006, she was awarded the Padma Shri, and also she received several literary awards like the Kerala Sahitya Akademi Award, Kendra Sahitya Akademi Award, Odakudal Award, Erthashan Award, and so on. Padira Pukal, Ratri Mala, Muthu Chippi, Pavam Manava Hrudayam, Tulavarsha Pacha, Radha Evide are some of her noted works. We extend our deepest sympathies to her family and join them in sorrow. Let's take a moment to extend our condolences to the demise of the departed soul. Okay, moving to our program. As you all know that we are gathered here for the inauguration of second district chapter of Law and Justice Research Foundation, that is Ernakulam chapter. In order to start the inauguration function, I invite Uttara Shekhar to co-chair the session. Uttara.
Thank you so much, Jumor. Am I audible?
Yes, you are.
Thank you.
Yes.
Good evening, everyone. Thank you. Thank you, sir. Good evening, everyone. Myself, Uttara. I'm a second year LLB student in Mar Gregorius College of Law and also a member in LJRF Trivandrum chapter. A journey of 1,000 miles begins with a single step. I would never find a better introductory quote than this for this extremely auspicious occasion of the official inauguration of the Law and Justice Research Foundation Ernakulam chapter. A very hearty good evening to each and everyone present here with us today. It's indeed a moment of joy and pride to each and every one of us who is a member of the LJRF family. I'm immensely honored to be a part of this prestigious function of the official inauguration of the Law and Justice Research Foundation Ernakulam chapter. To speak about LJRF, mere words are never enough. With a very short period of time, LJRF has marked its presence nationwide with its exemplary performance as an NGO, which worked with the motive of enhancing legal education and its practical sides to a wider sector in the society. Many informational programs and various innovative and socially relevant topics conducted by LJRF in association with various firms and organizations add on another feather to its hat of establishment. Sub-organizations of LJRF like the LJRF XM.in, LJRF Academy, and LJRF Voice, etc. was equally renowned nationwide and was able to seek a national attention with its meritorious performance and cooperation with various prestigious organizations like the Mandava Science Foundation Bangalore, Hindustan Institute of Technology and Science Chennai, Cochin Institute of International Arbitration, district probation offices, and various legal services authorities. They are just a few among them which LJRF has incorporated with. Internship programs for law students is yet another contribution from the part of LJRF for the welfare of law students and law education. LJRF being the product of the combined effort of various law academicians, advocates, research scholars, law students, and people from various other sectors is now extending its success journey to Ernakulam. It would have never been possible without the support and encouragement we got from various hands. At this moment of immense pleasure and joy, I wholeheartedly welcome each and every one of you to this function. Prayers don't have to be long and eloquent. They need to come from a sincere and humble heart. Nothing shines without the blessings of the Almighty. To grace us with His presence, I now invite Ms. Devika for the prayer service. That was indeed a heart-placing prayer service. Thank you so much, Devika. Before we commence with our program, I would like to bring into the attention of all the participants that make sure your audios are muted and none of you get engaged in any kind of presentations while the program is on. Before we commence with the program, I cordially invite Advocate Ajay R. Kamath, Secretary LJRF, to officially welcome us all. Welcome, sir.
Thank you, Uttara. Am I audible?
Yes, sir.
Okay. Welcome all the guests and members of the Law and Justice Research Foundation to this auspicious function. The Law and Justice Research Foundation, LJRF, was founded in May 2018. The main objective of the foundation is to promote constitutional legal literacy, legal awareness, and legal aid. The endeavor to sustain and promote the institution and legal instruments for securing justice to the poor and the weaker sections of the society is a constant and never-ending struggle which should manifest in the collective efforts of all who are the stakeholders of justice, which not only include the beneficiaries of justice through the law, but also importantly, the individuals who animate the mechanism for providing and promoting justice through the law, which includes the judges of the bench, advocates of the bar, academicians, legal scholars from legal education and legal research domain, and other luminaries serving in policy making in government and non-governmental organizations. Law and Justice Research Foundation aims to become a common platform for all the legal luminaries serving in the society in their different capacities with an aim to secure law and justice within India. With this note, the aim of the members of LJRF is to become the torchbearers to the spread legal literacy and awareness among common people and to provide legal aid to the needy in India. Inauguration of our second district chapter at Ernakulam is one milestone closer to our ambitious goal. On this auspicious day of inaugural ceremony of the LJRF Ernakulam chapter, I do hereby welcome Advocate Tejas Purushothaman sir, President, Law and Justice Research Foundation State Chapter. Next, I welcome Advocate KP Jayachandran sir, Honorable Chairman, Bar Council of Kerala. Next, I welcome Advocate Nagaraj Narayanan sir, Honorable Member, Bar Council of Kerala. Next, I welcome Advocate KK Nasser sir, Honorable Member, Bar Council of Kerala. Next, I welcome Advocate R. Lakshmi Narayanan sir, Honorable President, the Kerala High Court Advocates Association. Next, I welcome Advocate P.T. Jose sir, Honorable President, Ernakulam Bar Association. Next, I welcome Advocate Johnson Gomez sir, Director, Cochin Institute of International Arbitration. Next, I welcome Sri Sandeep Chandrasekharan, Joint Secretary, LJRF State Chapter. Next, I welcome Advocate Visrud R.S., Vice President, Law and Justice Research Foundation State Chapter. Next, I welcome Sri Gino M. Kurian, Director, Law and Justice Research Foundation Academy or LJRF Academy. Next, I welcome Ms. Rose Mariam Sivi, Member, LJRF State Chapter and Secretary, LJRF Trivandrum Chapter. Next, I welcome the heart and soul of Law and Justice Research Foundation, Sri Safi Mohan sir. And as the Secretary of Law and Justice Research Foundation, it's my pleasure and privilege to welcome all the eminent speakers and guests from different walks of life for sharing their knowledge and vast experience. I'm handing over the stage to the President. Over to you, sir. Tejas sir.
Hello. Good evening, good evening, dear all. Am I audible?
Yes, sir.
Can you hear me? Okay.
Yes, audible. Yes, audible.
ബഹുമാന്യനായ ഉദ്ഘാടകൻ, കേരള ബാർ കൗൺസിൽ ചെയർമാൻ KP സാർ എന്ന് ഏവരും വിളിക്കുന്ന പ്രിയപ്പെട്ട KP ജയചന്ദ്രൻ സാർ, ബാർ കൗൺസിൽ അംഗങ്ങളായ ശ്രീ നാഗരാജൻ സർ, ശ്രീ നാസർ സർ, ബാർ അസോസിയേഷൻ പ്രസിഡന്റുമാരായ ലക്ഷ്മി നാരായണൻ സർ, ജോസ് സർ, സെന്റർ ഫോർ ഇന്റർനാഷണൽ ആർബിട്രേഷൻ, ഇൻസ്റ്റിറ്റ്യൂട്ട് ഓഫ് ഇന്റർനാഷണൽ ആർബിട്രേഷൻ ഡയറക്ടർ ജോൺസൺ സർ, LJRFന്റെ ചീഫ് മെന്റർ ശ്രീ സഫി മോഹൻ, എന്റെ പ്രിയപ്പെട്ട കൊച്ചനുജന്മാർ LJRFലെ സഹഭാരവാഹികൾ ശ്രീ അജയാർ കമ്മത്ത്, ശ്രീ സന്ദീപ് ചന്ദ്രശേഖരൻ, വിശ്രുത് രവീന്ദ്രൻ, ശ്രീ ജിനോ എം കുര്യൻ, രാജേഷ്, റോസ്, നീലിമ, ജോമോൾ ആൻഡ് ടീം. ഈ യോഗത്തിൽ ഉദ്ഘാടന ദിവസം അധ്യക്ഷനായി ഞാൻ പങ്കെടുക്കുമ്പോൾ ഏറെ വേദനയോടെയാണ്. ഞങ്ങൾ ഏവർക്കും സുഖതേടത്തി എന്നും സുഖേടത്തി എന്നും ഞങ്ങൾ സ്നേഹാദരപൂർവം വിളിക്കുന്ന ഞങ്ങളുടെ പ്രിയപ്പെട്ട സുഗതകുമാരി ടീച്ചർക്ക് ആദരാഞ്ജലികൾ അർപ്പിച്ചുകൊണ്ട് ഞാൻ തുടങ്ങട്ടെ. സുഗതകുമാരി ടീച്ചറുമായി ഒട്ടനവധി സമരവേദികൾ പങ്കിട്ട എനിക്ക് ഓരോ സമരവും ഒരു അനുഭവമായിരുന്നു, ഓരോന്നും ഒരു പാഠമായിരുന്നു. ഏറെ ആത്മാർത്ഥതയോടെയുള്ള ടീച്ചറുടെ തുറന്ന സമീപനം സമരങ്ങളിലുള്ള പങ്കാളിത്തത്തിന്റെ ആക്കം കൂട്ടി. ടീച്ചർ അവശത അനുഭവിക്കുന്നവർക്കും അശരണർക്കും ഒരു അത്താണിയായ സുഗതകുമാരി ടീച്ചർക്ക് ആദരാഞ്ജലികൾ അർപ്പിക്കുന്നു. പ്രിയപ്പെട്ട ടീച്ചർ, പ്രണാമങ്ങൾ. ഇത് പറഞ്ഞുകൊണ്ട് ഉദ്ഘാടനത്തിനായി ശ്രീ KP ജയചന്ദ്രൻ സാറെ ക്ഷണിക്കുന്നു. Over to you, sir.
Hello. Yes. The president of this function, Advocate Tejas Purushothaman, Advocate Ajay Kamath, my dear brother, Advocate Nagaraj Narayan, member Bar Council of Kerala, my dear brother, Advocate KK Nasar, member, Honorary Treasurer, Bar Council of Kerala, the High Court Bar Association, High Court Advocates Association President, Advocate Sri R. Lakshmi Narayan, Ernakulam District Court Bar Association President, Advocate Sri P.T. Jose, Sri Safi Mohan, Advocate Sri Vishrut, Advocate Johnson Gomez, Advocate Jino M. Kurian, Ms. Rose Mariam Sibi, Sri Sandeep Chandrasekharan, and my dear respected participants. Good evening all. Hope it was a beautiful day for all of you. The Ernakulam chapter of Justice LJRF is launched today. I wish the foundation all success and really hope that they have great paths of success ahead waiting to be treaded. I had opportunity to associate with this NGO on multiple occasions. I am happy that I could be a part of this occasion too. Law and justice research is the karma undertaken by the foundation. Is law and justice different? Or does it suffer from the vice of repetition? Ask any lawyer and he would tell you they are different. Law and justice are different. Many a times, law and justice are strangers too. Laws can be made provided you have the majority in the legislature. Laws can be delivered by the court provided you
I think our speaker has got some connectivity issues. Let's wait for a few minutes.
ജയചന്ദ്രൻ
Sir.
മൈക്ക് മ്യൂട്ടാണ്.
Sorry for the inconvenience. Our speaker will be joining in a few moments. Hello, sir. Our speaker has rejoined, but I think his mic is muted. Jayachandran, sir, hello. Sir, could you hear me? Hello, sir.
So, okay, let us wait.
Okay, sir.
Yes, KP sir has joined. I think he will be able.
KP sir, you could unmute your mic.
Hello.
Yes, sir, you're audible.
Sorry for the trouble. Some net problem is here. Now, can you hear me?
Yes, sir, you're audible.
To deliver justice, what the makers and administrators of justice need is hands right on the pulse of the people, the affected, the victim, and the accused. By committing an accused to prison, a judge may be delivering the law and may be submerging justice. But then that is a topic as vast as the sea. Literacy is a popular word. We all know what it is, and we all know the ill effects of illiteracy. The scope and definition of literacy also keep on changing. For instance, take the case of the last generation. One who could read and write was literate then. Now, one who has bad skills and has no computer knowledge is still illiterate. Let us see what legal literacy is. Of course, in simplest words, legal literacy is knowing the law. Law is a profession too. There are the lawyers who are skilled in law. Then why should one learn the law? One could easily hire a lawyer. This may sound right. The analogy is this. If you have some infection, you don't go learn what infection is, what medicines are there, how it works, the pharmacopoeia of the medicine, etc. You are not supposed to learn it. You can hire a doctor. It is the same in all cases. Then why should you yourself know the law? The answer is simple yet powerful. Ignorantia juris non excusat, meaning ignorance of law is no excuse. This is the fundamental principle of law. Means you are legally obliged to know the law. Knowing the law makes one confident on any given situation. The root cause of all exploitation and denial of justice is legal illiteracy. When you know what your right is, you can demand it. As for India, the Constitution is our super strength. Every legislation must adhere to the Constitution. Any law that is unconstitutional would be struck down by the courts, High Court or the Supreme Court. The Constitution protects the people from arbitrary powers of the state. The Constitution of India is the supreme authority. Every legislation must adhere to the basic principles of the Constitution. Educating the people about the Constitution that govern them is important. This would mean educating about your rights, your obligations, and your limitations. Let us come to the Kerala scenario. Kerala soon launched its second phase. In January 2019. The Union government also actively promote constitutional awareness programs. The Union Ministry of Law and Justice also frequently release legal literacy handbooks. They include important constitutional provisions such as fundamental rights. Only with greater understanding of the Constitution can a citizen fully recognize his rights. The bar councils have important roles to play. There is a widespread apprehension among a small group of lawyers that educating the public about the law would mean destroying the opportunities of advocates. This, I think, is not true. The more people become aware of their rights, the more people will come forward to move the courts. The number of suits or litigations will skyrocket. Legal Services Day is observed every year in India on 9th of November. It is observed to lay emphasis on legal literacy and increase legal awareness among the people. It is the National Legal Services Authority that formed the foundation for Legal Services Day. As has been said by the former Chief Justice of India, Y.K. Sabarwal, the achievement of legal literacy is not an easy task. They too require the support of NGOs, particularly those which work at grassroots levels, international organizations, the media, etc. Organizations like the present one can do a lot in the field. Your efforts in this regard should not end by the end of the day. Recognize they have a legal right, responsibility in order to exercise or assume. Let me conclude with the permission of all who are present here. I declare that the Ernakulam chapter of Law and Justice Research Foundation is inaugurated. Thank you. Thank you all.
Thank you so much, sir, for sharing your most valuable words with us today and for the wonderful start you gave us. We are highly fortunate to have you with us, sir. Up next, we have with us Advocate Nagaraj Narayan, Member, Bar Council, Kerala. I consider it as my great honor to invite him to deliver the keynote speech on the topic Constitution after Keshavananda Bharati judgment. With most respect, I invite Nagaraj sir to illuminate us with the topic.
Respected, distinguished dignitaries on the virtual dais, including the Chairman of the Bar Council of Kerala, the President of the High Court Bar Association, and President of the District Bar Association, Sri P.T. Jose, and President of the Kerala Bar Association, my friend, senior friend, respected President of Kerala High Court Bar Association, Sri Lakshmi Narayan, President of the Ernakulam Bar Association, Sri P.T. Jose, and other distinguished guests on the virtual dais. It is really my honor to be here to deliver the keynote address on a very important and significant topic, which is the Constitution of India after the Keshavananda Bharati case. I hope I may not take a lot of your time, but just give some propositions and place some issues so that you may ponder on what the Constitution of India has been after the Keshavananda Bharati case. Now, you know that the Indian Constitution is modeled on the rule of law concept, which has been taken from the United States, from the constitutions of the unwritten constitution of Britain, United Kingdom, and the constitutions of United States and certain other countries, the basic proposition which we should all know is that the Constitution is a living organism. It is what creates us. Well, I need not tell you that going by the DNA profiling and the present day genetic studies, it is seen that the North Indian genes and genetical profile are more similar to the genetical profiles of those in Afghanistan and Pakistan. But there is so much difference in the genetic profiles between the North Indian and South Indians. But we have a country where South India and North India is united, but Pakistan and North India, which are sharing a DNA profile or genetic profiles, are separate countries. All this is because we have a separate constitution. Our constitution has created everything. Is the basis of this is our constitution. But as you know, the constitution is a living organism. It has evolved. Great jurists, legendary jurists, which have been recognized in jurisprudence, like Justice Oliver Wendell Holmes, one of the greatest Supreme Court judges of the United States, Justice Cardozo, Benjamin Nath Cardozo, another greatest judge of the United Supreme Court. They all say that the basis of a constitution is its workability to adapt to the changing needs. A constitution which cannot adapt itself to the changes in the society and the needs of society, or which is static, which is not flexible, such a constitution is going to be a failure. A constitution which is effective, a constitution which could give results, will be a constitution which is very flexible, which is very adaptable, and which could be molded according to the needs of the time, like soft clay. It should not be like rigid iron. Now, Cardozo himself says, very famous quotation, see, precedents drawn from the days of travel by stagecoach do not fit the conditions of travel today. See, what is said is, so those days of travel by stagecoach, when the horse, we were riding stagecoach driven by horse, the precedents which were developed during those days, those precedents will not fit the conditions of travel today, where we travel by jet, by airplane, by flight. So it has always has to evolve. That is why it is said, what Ambedkar, one of the founders of the Indian Constitution, what he intended at that time is not what is relevant now, but what he would have intended had he known the present day circumstances. That is what it means. That is more important. So why I'm saying all these issues is only to impress on the point that a constitution should always have flexibility, adaptability, and should be able to change according to the changing circumstances and needs of society. But when that is not permissible, the issue is the constitution loses its effectiveness. And this is very important in the context of Keshavananda Bharati versus State of Kerala, which is a landmark decision which would divide the constitutional history of India into two parts: the constitutional history before 1979 and the constitutional history after 1979. Now, what is the relevance of this Keshavananda Bharati? Because Keshavananda Bharati has now put in a limitation on the power of the parliament, The parliament is what we know as the sovereign of our state, the ultimate power of the state. The parliament, which is elected by the people, which is accountable to the people. Every 5 years, they are accountable, they are elected, they represent the people. So that parliament, which is the ultimate, paramount, the highest sovereign in the country, now is put in a limitation wherein the parliament is unable to amend the basic structure of the constitution. And if I may tell you, what is this basic structure? Well, there is no finality to that. Any day, the Supreme Court has got the power to enhance the heads of or the categories which may come under the basic structure. It has not reached a finality. Even as on today, tomorrow, the Supreme Court has not put a limitation on itself, saying that this is the basic structure. We cannot amend the basic structure. So Supreme Court can always amend the basic structure. They can increase, decrease. There is no finality. There is no conclusion. But the parliament is having the limitation. The parliament cannot amend the constitution. The inherent limitation is basic structure. But the Supreme Court doesn't have any limitation as to that because there is no conclusion as to it. Now, Keshavananda Bharati, as you know, is the largest bench, 13-member bench, which has ever been constituted in the Supreme Court. I may just take 1 or 2 minutes. Maybe I will not prolong for long and make it boring for you for hours. If I've gone to speak on Keshavananda Bharati, I can speak for hours. But I will limit myself to maybe another 15 minutes. So the background of Keshavananda Bharati may be understood. As all of you know, I need not tell you, I know it is a repetition. Shankari Prasad in 1951, Shankari Prasad versus Union of India. In 1951, immediately after the constitution came, the Supreme Court said the fundamental rights can be amended in any manner which the parliament, the sovereign of this country, which is the parliament, decides, because they are the repositories of faith of the people. So fundamental rights can be amended in any manner. And the Supreme Court also said, if a law is against fundamental right, Article 13 of the Constitution, which speaks about the doctrine of ultra vires, says that any fundamental right which is against a fundamental, any legislation, any law which is against fundamental right is void. It is invalid. It is void. So in Shankari Prasad was Union of India, Supreme Court said constituent amendment to the Constitution is not ordinary law. It is a constituent power. So it is not like the ordinary law. And only the ordinary law which is passed under the Constitution by the Parliament or by the state legislatures will be hit by Article 13 of the Constitution. And the definition in Article 13 of law doesn't include a constitutional amendment, and constitutional amendments are outside the purview of law. So the constitutional amendment, so that gave maximum flexibility, that gave maximum freedom to the parliament to amend the fundamental rights in any manner they want. Then came 1967, 1951, then 1967 was Sajan Singh. Sajan Singh was the state of Rajasthan. In Sajan Singh was the state of Rajasthan, by a 5 constitutional bench, by 3:2. 3 members agreed, but 2 members had a little doubt. And these are all great judges, Gajendra Gadkar, Vanchu, and all these judges, Gajendra Gadkar. So there was a 2-member bench, 2 members of the bench, out of 5 members. They expressed a different opinion, saying that they have doubt as to the reasoning or principle laid down in Shankari Prasad, because there is absolutely no limitation. Is something which they have a doubt. There should be some limitation in the amending power. But anyhow, the majority said, approved Shankari Prasad, and that held the field. Now comes the major decision in 67. The other one, Sajjan Singh, was in 1964. Now comes in 1967 is I.C. Golaknath case. Now, I.C. Golaknath was a state of Punjab. In that case, the Supreme Court reversed the propositions that were laid down in Shankari Prasad and Sajjan Singh. And the Supreme Court said that fundamental rights, so the law in Article 13 of the Constitution includes not only ordinary law, but also an amendment to the Constitution, which is, even though it may be a constituent power, but still that is also included within the definition of law. And as a result, fundamental rights cannot be amended at all. So that created a situation wherein the hands of the parliament was completely tied, in a sense that the parliament has no power at all to amend any provision of fundamental right. They cannot touch the fundamental right. If they touch the fundamental right, it will be violating of fundamental rights. It will be void. So I.C. Golaknath has put a complete curb. It has fully tied the hands of the sovereign, the parliament, by putting, it has made the constitution totally inflexible. Or it has made the constitution as if it cannot adapt to any of the situation. So then, Indira Gandhi, who was very powerful at that time, wanted to bring about many amendments which were against fundamental rights, or she wanted to take out some fundamental rights. But because of this decision in I.C. Golaknath, she cannot do. So she brought a new amendment to the constitution, wherein she has specifically said amendment to the constitution does not include within the definition of what is said in law. So the law in Article 13 will not include an amendment. This was specifically included as 13(4) of the Constitution. Now, that came before Keshavananda Bharati. In Keshavananda Bharati, there were so many issues. 24, 25, 26, and 29 amendments were under challenge. A lot of issues, Article 31C, a lot of issues were there. But one major issue, which I may highlight for today, is the only issue I may highlight is the issue as to the amendability, or how it could be amended. So this issue only was a major issue before the 13-member bench in Keshavananda Bharati. If they uphold Indira Gandhi's amendment of Article 13, I say Article 13(4) was only one of the many amendments. There were several other amendments made, but I am highlighting only this one. So if 13(4) is amended, if 13(4), the amendment to 13(4) is upheld, then the parliament will have absolute power, unlimited power to amend the constitution. If it is struck down, then the position will revert back to Shankari Prasad, revert back to I.C. Golaknath case, by which fundamental rights cannot be touched. Absolutely no amendment. So Indira Gandhi wanted to amend the fundamental rights. Indira Gandhi wanted to remove some fundamental rights. But if I.C. Golaknath case is there, fundamental rights cannot be touched. The parliament's hands are fully tied. Parliament is powerless. There is absolutely no flexibility for the constitution. So if that amendment is not upheld, if it is struck down, I repeat, at the sake of repetition, I say, if that amendment is struck down, the parliament will become something like completely inflexible. The parliament will be something where the parliament will not have the power to amend the constitution at all. Fundamental rights they cannot touch at all. They cannot do anything. So the court cannot strike down the amendment. If the court struck down the amendment, then I repeat, at the sake of repetition, I say the parliament will be by going by IC Golaknath, that position will revive. So it is to take away that position this amendment was brought. And if IC Golaknath position is revived by striking down this amendment of Indira Gandhi, then Parliament will be fully tied, his hands will be fully tied, and the constitution will be a constitution which will be completely rigid, not at all flexible. Fundamental rights cannot be touched. So the Supreme Court, so it's a clear case of judicial creativity. The Supreme Court did not want to strike down this amendment. Striking down this amendment is very dangerous. It will go back to the position of IC Golaknath, which the Supreme Court did not want. But at the same time, if it is upheld, then the Parliament is having unlimited power, absolute power. The Parliament can do anything with the fundamental rights. That also they did not want. So they struck a biomedia between these two. So biomedia between not giving any power at all to the Parliament by taking away all their power of amendment, that they don't want to do. On the other hand, they also don't want to give too much power to the Parliament to amend. So a biomedia had to be done. And that is the judicial creativity that was done in Keshavananda Bharati through the principle of basic structure. And it has been criticized a lot as saying it is judicial, constitutional lawmaking, judicial lawmaking, constitutional lawmaking, where the court basic structure as such is not there, but through an interpretation of the constitution, they have laid down a new principle of and put an inherent limitation on the amending power. So it was criticized a lot. So I should say that only 7 judges said this judicial creativity was exhibited by 7 judges. And 6 judges went by the principle of what was stated in Shankari Prasad and Sajan Singh. And they fully disagreed with what was stated in Golaknath, saying that they upheld the amendment fully and said the power of the Parliament is unlimited to amend any fundamental rights. So that was most of them became Supreme Court Chief Justice later. It was Justice Ray, Justice Beck, Justice Dwivedi, Justice Matthew, Justice Chandrachud, that is Father Chandrachud, and Justice Palekar. These were the 6 judges who said the Parliament has absolute power, the amendment is absolutely valid, no limitation. The other 7 judges, out of the 7 judges, 6 judges were almost going together in almost all issues. One judge, Justice Khanna, was in between. He was not going fully with both sides. The Chief Justice of that bench was Justice Sikri. Then 2 other judges, Justice Sellet and Justice Grover, they gave one judgment, one opinion. Justice Hegde and Justice Mukherjee, they also gave another opinion. Then a separate opinion was given by Jagamohan Reddy. So these 6 judges were sailing together and the other 6 judges were going the other way. When it came to basic structure, it was Khanna's judgment which shifted the majority in favor of the other 6 judges. So these 7 judges together brought in a concept of judicial creativity by saying, we agree with the minority, we also uphold this amendment. The Parliament's power to amend cannot be curtailed. Parliament can amend the fundamental rights. So what is said in IC Golaknath that Parliament cannot amend the fundamental rights is absolutely wrong. All the 13 judges agreed on that. But these 7 judges said, though you can amend the fundamental rights, you amend any fundamental right, you take away 14, 15 or 16, 17, anything, but don't take away the fundamental rights. But these 7 judges who gave 5 opinions, because Shellett and Grover gave 1 opinion, Hegde and Mukherjee gave 1 opinion, so 2 opinion, then Sikri 1 opinion, 3rd opinion, then Jagamohan Reddy another opinion, and Khanna another opinion. So 5 opinions. Now they reflected on what is basic structure. So it was subsequently criticized a lot. H.M. Sirvai has criticized, P.K. Tripathi, another great jurist, has criticized, Rajiv Dhawan has criticized, Ubendra Bakshi, one of the greatest legends, living legends of India, legal legend, he has criticized. They all say, we don't know what is basic structure. Even these judges don't know what is basic structure. Because one person has listed 7 things, 7 concepts as basic structure, another has said 4, another has said another 5. So if you take all these, I don't have the time to go through all this. I'll just rush through this. I'll just say that if you take all these, there are many concepts, many principles which are fundamental rights, which are basic structure, then you cannot amend the constitution at all. It is as good as saying that you agree with IC Collar. You say you don't agree with IC Collar, you can amend the fundamental rights. You are bringing too many things into basic structure. So it was a very confusing concept. People said that this is not going to stay because another bench may find it difficult to find out the ratio. Then came Indira Nehru Gandhi versus Rajnarayan in Keshavananda Bharati was in 1973. And then came the other judgment in 1975 in Indira Nehru Gandhi versus Union of India. Rajnarayan, sorry. Indira Nehru Gandhi versus Rajnarayan. That is 1975 judgment. Now, in that case, what happened was Indira Gandhi brought a drastic amendment. 329 4A was included in Article 329. Now, what was this Article 329 4A? It said that if there is a declaration attached saying that the Prime Minister and Speaker have been declared elected, nobody can challenge it. The Prime Minister and Speaker, if they are declared elected, their election cannot be challenged. Whatever way, in whichever manner, in whichever way they have come to this post, they got elected by manipulation, by corruption, or whatever happens, by electoral, by bribery or malpractice or electoral offense, electoral practices, nobody can challenge it. So it was brought beyond the review of judiciary. And it was said by, if you read Upendra Bakshi's Courage, Craft and Contention, he very beautifully says that in the bench constitution, there was a very interesting thing. Out of the 5 judges, 4 of the judges were those who dissented in Keshavananda Bharati, saying there is no basic structure. And only one, Justice Khanna, was the only person who was on the other side. So 4 of the judges in Indira Nehru Gandhi were persons who said, we don't agree with basic structure, who had dissented. So it was said that it was easy for these 4 judges to say, easily they could have said, see, we cannot discern, because that was the majority juristic opinion at that time, because a basic structure is not designed, it's not discernible. It isn't something like fluid. You don't have a principle which is, they could say it is not as such, not found out, and we cannot apply basic structure, they could have said. But I would say, fortunately, for the betterment, for the future of our democracy, that is why I say fortunately, all the 5 judges unanimously said, this is too undemocratic to be sustained, that we go by basic structure. And one more thing they did, they, reading through all the judgments, they churned out, brought in 3 principles as the fundamentals of basic structure. They said, a lot of things have been said, but from all the 5 opinions of the 7 judges, what we could churn out is these 3 things are basically part of the basic structure. This is what we understand as basic structure. Maybe a lot of things have been said, but if we can churn out a ratio, then these are the 3 principles. One is rule of law, the other is democracy, and third is judicial review. Then matters were standing like that. If matters have stood like that, well, we could have known that basic structure has a finality. Nothing more is added. But matter didn't end there. We were all after 1975, juries were of the opinion that now we finally have a finality situation, wherein we know that, see, these are the only 3 principles which are basic structure. If it is again rule of law, democracy, this. Now, then what happened is, the 1980 Minerva Mills case came. Then again, it started expanding. Then Padam Kumar Prasad case came. It said independence of judicial is also part of basic structure. Then in another SR Bombay came. It said SR Bombay case. It said that it is secularism is part of basic structure. Then still, I am a person. I may say secularism should be part of the basic structure, but it is the majority of people decide it is not secularism. It is left to them to decide it is not secularism, because I may be maybe in the minority to say secularism should be there. But there are a lot of concepts. Then federalism, it is part of the basic structure, is some of the judges mentioned in SR Bommai, and some other cases also it has been said federalism is part of the basic structure. Now, whether we have federalism is another question. How far we have federalism, whether we are unitary, whether we have federalism or semi-federalism, it is a debated point. But they say federalism is a basic structure. Tomorrow, somebody wants to make it not basic structure, because we are not based like the American Constitution, whether all these states have joined through various covenants and agreements. We have not joined. We have all been joined through force. Some of them optionally. Those who have not joined by option, they have been used by force and various other tactics. So no consent is there for any state, and states have been created by it's all creation of the unitary act of the parliament, and of course by ratification by the states. But now whether federalism will be part of the basic structure or not is another question. So it has started expanding, and independence of judiciary is said to be part of the basic structure has created a lot of problems. So that is why I'm saying that now the parliament, the power of the parliament to change the constitution according to the needs of the time has now been curtailed. Its hands have been tied. And who will untie this? Who will bell the cat? And now there is a powerful judiciary which says that you cannot make any law saying it is against basic structure, which is independence of judiciary. For example, we know what happened to the National Judicial Commission. Judges 1 case, Judges 2 case. Judges 2 case, what has happened? Judges 2 case has brought in Supreme Court advocates on record versus Union of India has brought in the collegium system. Now, where is the collegium system set? This collegium system is something which is unique only for India. Nowhere in the world you can find anything like collegium system. And it is not anywhere in whatever interpretation you give to the Constitution. The Constitution only says consultation with the president may appoint a judge in consultation with the Chief Justice. How can you read in too much into the consultation process saying a collegium? It's all creations. No legislation. The people have entrusted the power with the parliament, the state legislatures. No. This mandate is not used. From where did the mandate to make such a legislative nature, constitutional nature of a body of collegium system came to Supreme Court? Nobody knows. And it is existing as the law of the land. And we are all bound by that. And the Supreme Court is the highest body which is regulating everything. It is playing so much of role in our day-to-day life. And I may just conclude by saying, maybe another 5 minutes I'll conclude. So, the Judges 2 case brought in something like a judicial legislation, a constitutional legislation, or a constitutional amendment, brought in this word of collegium system nowhere to be seen, where it is, where it can be read in the Constitution. If you show it to some foreign jurist, he will ponder over it again and again and read, and how this has been interpreted like this. They will be water stuck. How this system came. So how much of exercise has been taken in that Judges 2 case to bring in this? Now the very same judge who has brought the collegium system, they are lamenting and saying we should not have brought this. Now it comes to Judges 3 case. And what has happened? National Judicial Commission. Now the Supreme Court has brought in something. Of course, it should be left open to debate. You can say that things could be like this, but it's ultimately the power. Unanimously, the Parliament has passed this. But it has been declared unconstitutional on the ground. It is against basic structure. It is against independence of judiciary. Independence of judiciary is part of the basic structure. It's said. And what is this concept? What is the content of independence of judiciary? It is the power of the judiciary to be absolutely free without any check and balance. Of course, you say the parliament has to have some check and balance. But what is the check and balance for the judiciary? When the ultimate, there should be mutual check and balance, of course. But what happens to the ultimate decisions of Supreme Court if they are against the Constitution? Where is the check and balance? So, you find these judicial creations, judicial amendments in the collegium system, and all these as offshoot of basic structure. And maybe Keshavananda Bharati could be appreciated as a judicial creativity, and that's those days of judicial creativity when it was put behind these two issues. You know that what has happened after Keshavananda Bharati? 3 judges were superseded because they gave the basic structure judgment. Shellett, Hegde, and Grover, they were superseded. Hegde's son later became a Supreme Court judge. You all know that. Then, Shellett also, his son also, if I'm correct, his son was also a judge. Then what happened? After the Keshavananda, all these senior-most three judges were superseded, and Ray, who was junior to them, was made the Chief Justice. Consequently, all the three senior-most judges resigned because of their dignity, self-respect. I don't know whether that would happen nowadays if somebody is superseded. Whether the senior man will resign or not, only time will tell. But at that time, they were people with self-respect that resigned. They were not ready to work under a junior.
Hello, sir. I think our speaker has got some connectivity issue.
Sorry, I lost my net connection in between. Absolutely.
Okay, sir.
I hope.
We can hear you now.
Okay. I lost. So I'm just concluding myself by saying that though it had a noble object, because at that time Indira Gandhi was going towards dictatorial tendencies. Maybe you may disagree with me. Can you hear me?
Yes,
Can
sir.
you hear me?
Yes, sir, we can hear you.
Yes. So maybe at that time, the Supreme Court felt that if absolute power is given, absolute power corrupts absolutely, like that. Indira Gandhi was showing some dictatorial tendencies. So maybe some limitation should be put in. And they were not sure as to what were the limitations. And that is why in Keshavananda Bharati, the majority gave so many opinions as to what constitutes the basic structure. The basic structure was given with a noble object. But how it has been interpreted subsequently, because even now there is no cap or no restriction on the Supreme Court not adding new heads to basic structure. So presently, after Indira Gandhi, though it had got a finality as to what it was, there was some more clarity to what was basic structure. But subsequent decisions have all added more and more categories of propositions into basic structure, principles. And as a result, we see what has happened in Judges Case 1, 2, and 3. And now the Supreme Court has become almost all powerful. And it is not judicial activism, it is actually judicial constitutionalism. It's constitutionalism to the extent that judiciary has even got the power to amend the constitution through interpretation. It has reached such stages. So when the executive was very powerful, when Indira Gandhi was very powerful, all this activism was not to be seen. What happened in JDM Jabalpur? Some of the greatest judges, including Bhagwati, was there in the majority. Bhagwati, Justice Chandrachud, Justice Ray. What happened? We all know. Nobody was there to challenge the might of the executive. Now it is on the other side. When the executive became very weak, maybe the Judges 2 case came at a time when the executive was at its weakest point, when there was a hung parliament, when Narasimha Rao was there, and just during that period only the Judges 2 case came, the collegium system came. So now it has been continued, and now there is no check and balance over the judicial side. Who will check the judicial side? So it is all the effect. Maybe you may disagree with me. The proposition I may put before you is that Keshavananda Bharati had a noble object. The basic structure doctrine had a noble object. It had so much of judicial creativity. It was a balancing act between giving too much power and no power to the parliament. So giving full power to the parliament at the same time putting some check, some rider over the power. But now it has come to such a stage that the parliament's hands are tied in such a way as seen in the National Judicial Commission. And people are still thinking about another judicial commission, but we don't know what is going to happen. It's like the American realism, wherein it is only probable. We don't know whether the Supreme Court will approve it or not, whether it will be again be tested on the touchstone of the basic structure of independence of judiciary and say this is against independence of judiciary. Does independence of judiciary means that the power of appointment should only be with a 3 judges, senior most judges? Does any constitution in the world give such a power to the judiciary? I don't think so. If I'm wrong, please point out. Judges selecting judges themselves and without no restrictions as such. Of course, now the executive is putting up restrictions, but even there it is said once it is rejected back and returned again by the Supreme Court Collegium, the executive can do nothing. Powerless. Is there any system like that anywhere in the world? That the executive is totally powerless and the judiciary is having all power to make appointment of judges? Well, these are things to be pondered, to be thought over. I'm just putting all this as questions for you to think over and find solutions. With these words, I'm very happy that I have been given a platform. I have been given this opportunity. Of course, I wanted to come with a PowerPoint presentation on Keshavananda Bharati and with this, but because I was held up with many other issues, I could not. I have reached only now to Trivandrum. I was here. I reached Trivandrum, but I had some places here. So I'm very sorry I could not come with a PowerPoint presentation, make it more entertaining and more illuminating. So with whatever I said, with leaving these questions to you, thank you very much, organizers, especially Safi Mohan, Vimal Kumar, Tejas Menon, and all others. And I also thank Lakshmi Narayanan sir, my dear friend, my senior friend, for being in this the August audience, listening to my speech. Thank you, sir. Thank you very much. And KP Jose also, I'm thanking so much. President of Ernakulam Bar Association. So both presidents are so much involved in all academic activities. I'm very happy to know that our High Court Bar Association president and Ernakulam Bar Association president are very much involved in all the such programs. Very happy. And of course, I thank Sri KP Jayendra sir also for being with me, for listening to my speech. Thank you all. Thank you very much.
Thank you so much, sir, for providing us with such a knowledge, and it was truly, it was highly effective, sir. Thank you so much for your words. Now, please allow me to welcome Advocate K.K. Nasa, Member, Bar Council Kerala, to give away the special address and to enlighten us on the topic, Role of Bar Council for Continuing Legal Education in Kerala. I welcome you, sir. Hello, sir. I think our speaker has got some issues and he's not in the meeting. Sorry for the inconvenience. Moving on to this felicitation program. For the felicitation speech, we have got a few settlers and talented speakers today. For that, I invite Advocate Lakshmi Narayan, President, the Kerala High Court Advocates Association. I now invite you for your words, sir.
Respected President of the meeting and the President of the Foundation Advocate Tejas Purushothaman, respected Bar Council of Kerala Chairman, Advocate K.P. Jayendran, my esteemed friend Nagaraj Narayanan, K.K. Nazar, and Advocate P.T. Jose, the President of the Ernakulam Bar Association. I'm immensely delighted to attend this webinar in which the inauguration of the Ernakulam district chapter of this foundation has been just, we have witnessed the inauguration. I'm extremely happy that this organization, through its own efforts and the ancillary organizational setup created by it, doing immense service not only in the field of the law and justice, but also good work of charity and other social commitment reflections activities are also being done. I am grateful to the office bearers for doing this charity, especially when the need of the hour is that we should have some sympathy and empathy towards our fellow beings. So it is said that the justice is the greatest interest of the man on earth. It is by Daniel Webster. So this foundation doing great service not only in the field of justice, it's and the energy by the combination of the lawyers, the researchers, the law teachers, and all, and the synergy generated out of their combination is producing good result for the society also. I am happy that you have invited me to participate in this function, and I hope that with your efforts, the office bearers' commitment, and with the voluntary help extended by the external persons who are the beneficiaries or who would like to enhance the working of this institution by contributing by, I don't know whether you take financial assistance or you are taking volunteers for your work, but by all this combination of activities, this organization, I am very hopeful that this will scale more heights in this legal arena, not only in the legal arena, but also the social commitment work. It is being imparted for the time being. I wish all the success on behalf of the Kerala High Court Advocate Association. Also, I am wishing all success to this organization and its activities. Thank you. Jai Hind.
Thank you so much, sir. Thank you for your kind words. Next, I invite Advocate P.T. Jose, President, Ernakulam Bar Association. We are all eager to hear from you, sir.
Yes, respected President of the meeting, Advocate Tejas Purushothaman, respected Chairman, Bar Council of Kerala, Advocate K.P. Jayendran, Advocate Lakshmi Narayanan, the President of the Kerala High Court Advocates Association, my dear friend Advocate Nagaraj Narayan and Advocate K.K. Nazar, the members of the Bar Council of Kerala, other office bearers of the Law and Justice Research Foundation, distinguished guests, ladies and gentlemen. Today we have witnessed the inauguration of a district level working of foundation. I am glad that the foundation has proved itself worthy by conducting many activities, not only confining to the fields of law and justice, but also reflecting its social commitment. It had extended helping hand to the needy and also made access to justice a reality. It is heartening to note that some organizations of the foundation absorbing energy from the foundation are doing immense service to the society to achieve the laudable objectives of the foundation. I think that today we have conducted the inauguration is really a need of the hour. I hope and pray that the foundation may attain a greater heights and thus fulfill the aspirations of the society, and I am eagerly waiting to be benefited by its activities. On behalf of the legal fraternity of Ernakulam and as the President of Ernakulam Bar Association, I wish all success to the foundation and its activities. Thank you.
Thank you so much, sir, for your kind words. We also have with us the most respected Advocate Johnson Gomez, sir, Director, Cochin Institute of International Arbitration. I request you to grace today's occasion with your words, sir.
Thank you, Uttara. The president of this meeting, Advocate Tejas Purushothaman, President LJRF, Advocate KP Jayachandran, Chairman Bar Council of Kerala, Advocate Nagaraj Narayan, Advocate KK Nasser, members of the Bar Council, Advocate R. Lakshmi Narayan, President of the Kerala High Court Advocates Association, Advocate P.T. Jose, Ernakulam Bar Association President, Mr. Safi Mohan, who is the backbone of this organization, and all the members of the LJRF. I sincerely place on record a sense of gratitude for having invited me for felicitating in this important occasion where the LJRF is extending its wings to the Ernakulam district. Our association with LJRF is primarily on two areas. One is we have a project in which Cochin Institute of International Arbitration is working along with LJRF in a program called Complete Lawyering. I believe that the details of the program will be discussed later in the event itself. And the other program in which Cochin Institute is associating seven sessions. To be education. We will find that there is a huge may include litigation practice, non-litigation practice, and other areas. Now we find that this bridging the lawyers and law teachers. So before we have formulated particular we intend to have a 7-year training role book. Moving in accordance with the rule book that is being prepared. This program is being conducted in such a manner that the lawyers and law teachers associate, so that we will find more and more law students joining the legal profession. The second area that we are discussed is arbitration training, and Cochin Institute in the coming weeks may be opening our arbitral institution, and we may be extending clinical training in arbitration also for the members of the LJRF. Anyhow, I wish to place on record the wholehearted support that is being extended by LJRF in the activities in the above activities has to be applauded. And I wish LJRF all success in future. And thank you very much for inviting me for this event. Thank you.
Thank you so much, sir, for your kind words. Hoping to have the same cooperation in the future events also. Next, we have our LJRF program presentation. For that, I now invite Sri Sandeep Chandrasekharan, Joint Secretary, LJRF State Chapter. I welcome you, sir.
Am I audible, Uttara?
Yes, sir.
Yes. Thank you, Uttara. Thank you for the opportunity. First of all, respected Chairman, Bar Council of Kerala, Advocate Sri KP Jajan sir, respected Member, Bar Council of Kerala, Advocate Sri Nagaraj Narayan sir, respected Member, Bar Council of Kerala, Advocate Sri KK Nasir sir, then respected President, Kerala High Court Advocates Association, Advocate Sri R. Lakshmi Narayanan sir, then respected President, Ernakulam Bar Association, Advocate Sri P.T. Jose sir, respected Director, Cochin Institute of International Arbitration, Advocate Sri Johnson Gomez sir, respected President, Law and Justice Research Foundation, Advocate Sri Tejas Purushothaman sir, Vice President, respected Vice President, Law and Justice Research Foundation, Advocate Visruth R.S., then respected Course Director, Law and Justice Research Foundation Academy, Sri Gino M. Kurian. Then we also have with us Ms. Rose Mariam Sibi, member, respected member, Law and Justice Research Foundation, and also Secretary of Trivandrum State Chapter. My responsibility here is to very briefly mention the programs conducted by Law and Justice Research Foundation. As our respected Secretary, Sri Advocate Ajay Kamath has mentioned, Law and Justice Research Foundation has multiple goals. Among them includes spreading of constitutional awareness. For this purpose, with the objective of spreading constitutional awareness, Law and Justice Research Foundation has initiated unfounded the Center for Constitutional Literacy, CCL. And the Center for Constitutional Literacy was inaugurated by the Honorable Deputy Speaker of Kerala Legislative Assembly, Sri V. Shashi, on June 2019. And the objective of the Center for Constitutional Literacy, established by Law and Justice Research Foundation, was to spread constitutional awareness, spread awareness of the values and philosophies of Indian Constitution among the public. And one of our first initiative was to launch a clinical legal aid camp within Chirangire, where the Center for Constitutional Literacy is established, the Chirangire constituency in Trivandrum. And it was followed by a series of lectures on fundamental rights that was hosted with the auspicious of auspicious of Law and Justice Research Foundation. And then we Center for Constitutional Literacy also very recently conducted a webinar on the socio-legal significance of government law colleges in Kerala, where we discussed the challenges and opportunities that are available to government law colleges, and the contributions, the social reform contributions made by the government law college as an institution within Kerala. And this was discussed by a panel of experts, and the webinar was hosted in November 2020. And another initiative of Law and Justice Research Foundation that is currently ongoing is the Complete Lawyering project that has been mentioned by Advocate Johnson Gomez sir. And this Complete Lawyering is the brainchild of Advocate Johnson Gomez sir, who is a member of the Lex Expertians and one of the founders and director of Cochin Institute of International Arbitration. And he came to us, members of the Law and Justice Research Foundation, to implement the Complete Lawyering project. The main vision of the Complete Lawyering is to make a law graduate a successful lawyer within 2 years after graduation. And we start this process from the law schools itself. That is, if the student is going through the 5-year program, the process of making him a successful lawyer will take up to 7 years. And if he's from the 3-year program, it will take up to 5 years. So the steps that we are planning to take in order to make a law graduate a successful lawyer within 2 years, it starts from the law school itself. And how it is done through the cooperation of academicians within legal educational institutions in collaboration with senior advocates. The objective is to make it more formal. That is, we are aiming to bring a syllabus, a written book, a guidebook in order to guide the law students who are participating as interns in the legal firms or senior advocates, and also to guide junior advocates in the basic steps that they must take in order to activate the powers, the legal powers that is vested within each and every legal institutions created under the law. Actually, as lawyers, we must take certain steps, and the steps are provided in the procedural law. And this guidebook, the so-called guidebook, will be connecting the procedural law with the substantive law, and it will guide the instruction, the interaction between the senior advocate and the junior advocate in imparting the soft skills that are necessary to make a junior advocate a successful lawyer within that 2 years that we have mentioned. The members and volunteers of the Cochin Institute of International Arbitration and Law and Justice Research Foundation are closely working with each other to bring up a concept paper which will be implemented into a corporate social responsibility CSR project. And we are planning to implement it as a CSR project with the help of CSR funds. And this is an ongoing process. And I believe the Complete Lawyering Project will help Law and Justice Research Foundation in achieving its goal of reforming the legal profession. And we are glad to associate with the Cochin Institute of International Arbitration in achieving the complete lawyering concept. Then then another one that we are doing in association with the Cochin Institute of International Arbitration is the online webinar series of webinars on international arbitration, on the basic principles of arbitration. And that series of webinars are ongoing, where we are imparting knowledge, we are imparting experience and knowledge with regard to the developments that are happening in arbitration. And we are trying to inspire law graduates to enter into the profession of arbitration, which is an emerging area, which is we believe will be the future of legal practice, one of the emerging areas in legal practice, which we need to capitalize as legal professionals. Then finally, as a result of the webinar that was conducted by the Law and Justice Research Foundation. Am I audible, Uttara? Hello?
You're audible, sir.
My apologies. I'm conducting this where I'm joining this session through my mobile phone, and I'm having problem with my connection. Yes, as I was saying, so as a result of the webinar that was conducted by the Center for Constitutional Literacy in association with the Law and Justice Research Foundation on the social legal significance of normal law colleges, challenges and opportunities. As I have mentioned earlier, there was a panel discussions on the possible challenges and opportunities that was facing by the government law colleges, and the panel discussion came up with a lot of conclusions and suggestions. And the Law and Justice Research Foundation, in order to further study the conclusions and suggestions made by the panel members in that webinar, has constituted the Law and Justice Research Foundation Legal Education Reforms Committee. The Legal Education Reforms Committee is headed by Dr. Saroja A.S., who is a former principal, who was the former principal of Government Law College, Trivandrum, Ernakulam, and Trishul. And the objective of the Legal Reforms Committee, the short-term objective of the Legal Reforms Committee is to conduct further studies on the conclusions and suggestions made by the panel discussion in the webinar on the socio-legal significance of government law colleges, and to make the conclusions and suggestions that was derived in the panel discussion into a policy paper. And this policy paper will be submitted before the concerned authorities to implement the conclusions and suggestions in order to reform the legal framework which is governing the government law colleges. And hopefully, it will further aid the government law colleges in achieving its social-legal significance, the so-called social-legal significance that was identified in the webinar. And in the long run, the Legal Education Reforms Committee aims to review the current developments that are happening in the legal education arena, and also eventually influence the direction in which the legal education is developing within Kerala and also across the country. And these are the projects that Law and Justice Research Foundation is taking. Projects are going on currently. And there are also other projects that are being taken up. These are the 3 projects that I will be discussing upon. In order to discuss the next projects that are taken up by Law and Justice Research Foundation in association with other institutions, I will be playing a video that has been made by one of our member, that is Sri Gino Empurian, who is unable to join this session. Nevertheless, he has sent a video recording, which I will be playing here. And I believe it is a very long video recording, but hopefully I will be able to play around 10 minutes of the video recording, and the remaining video recording will be shared in the website where you can see, all of you can see the full video. Okay, let me try to share it as a screen presentation. Please wait. Uttara, I need your assistance to confirm whether the video recording is audible or not. I will be.
Thank you. Honorable dignitaries, respected guests, members of LJRF, advisors of LJRF, and well-wishers of LJRF, and all of you who have gathered on this online platform today. I'm so happy and proud to address all of you on behalf of Law and Justice Research Foundation and its initiative. Today, we are achieving another milestone in our journey. Now we have a long way to go together. When LJRF achieves another milestone, I believe this is increasing our responsibilities and commitment to all of you and to the society. LJRF is not just a self-centered organization. It is contributing to the society. It is working, it is aiming for the development of the society by making changes in the society, by making changes in the existing pattern of working of legal community, legal professionals, law schools, legal scholars, and everyone. Being part of legal community, we all know that we want to make changes. But what kind of changes it should be? Where we need to make change? How the changes can be put forward? What will be the result, outcome? Here, until now, we were not having any answers. But now, we have an answer for you. LJRF, Law and Justice Research Foundation. LJRF, we have separate wing working on researches. We have separate team working on various social legal issues existing in the society. We have lawyers, we have scholars who are inculcating proper legal education for students and aspirants of law. We have separate wing working on reformations needed in the profession, especially in the practice, and also how we can make useful the course, the law legal program, which is provided by our law schools and law colleges. We have separate wing working for arbitration. We have separate wing working for constitutional literacy, and so on. Our aims are visible to all of you. We don't have any hidden agendas, but we always keep transparency, and we are in the society, and we became an inevitable part of legal community of Kerala now. My previous speakers have already spoken about many of our initiatives, and now this is my turn to talk to you about few of them in detail. LJRF Academy. LJRF Academy is an academic wing of LJRF, which is aiming to provide training and make awareness of law for government employees and social workers. One of our latest initiative is along with district probation team of Pathanamthitta, which is initiative is along with district probation team of Pathanamthitta, which is under the Kerala State Social Justice Department, and also along with Kerala State Legal Services Authority, the KELSA. We put forward a course for strengthening the capabilities of members of probation support team in various districts of Kerala. It is capacity development program for probation support team. This program has started on November, and it will be ending on January. Examination department of LJRF will be conducting an online assessment for them. An important thing behind this program is Kerala State Social Justice Department has put forward, has issued a notification, a government order asking all probation officers of second grade and probation office assistants to attend this program mandatorily. We believe this as a recognition for the efforts of LJRF and support of all of you who encourage our works and our programs. Along with this program, we were able to provide around 10 members from LJRF district chapters to work as part of probation support team of various districts of Kerala. Also, along with this program, we were able to come up with a criminal justice reforms committee headed by Professor Mohan Gopal Sir, Professor Sanoja Madam, retired District Judge Vijay Kumar Sir, and also associated with various professors from law colleges of Kerala, lawyers, social workers, and many other experts related to this particular program. We were able to come up with a new committee for plea bargaining, especially considering particular cases which can consider for plea bargaining. Our lawyers, LJRF member lawyers for various districts, will be working on particular cases, and they are examining application of plea bargaining in that. And these are all aiming to make reformation in criminal justice system and trying to rehabilitate offenders of all kinds of punishments. Along with LJRF Academy, we have another academic app, lawexams.co.in. It has been started since a long time. It is also from the founders of LJRF, Professor Safi Mohan. Lawexams.co.in supported a lot of aspirants of law exams like state level PSC related law exams, Kerala lectureship exams, government law colleges lectureship exams, UGC NET, CLAT LLM, and many such kinds of state and national level competitive exams. It is acting as a digital platform for developing teaching skills and providing assistance for aspirants to prepare for the various kinds of law or legal related exams. Recently, we put forward a new program under the TDP and RDP, which is the Teachers Development and Research Development Program called GetNet. This is for aspirants of UGC NET and JRF exam. They can come forward and write our online exam. If you are being selected, you will be getting 7 months online training program given by LJRF Academy as along with lawexams.co.in. You will be getting number of materials prepared and already we are having and also developing by our research and development team. Our research and development team consists of various levels. It is starting from the interns who are going to join with us on this January 4th through our new internship program of 30 days. This internship program is introduced by LJRF Academy, LJRF, along with law exams. And students of various colleges in Kerala as well as India are attending this program. They will be contributing to our materials which are going to be reviewed by our research and development team. We have editors who are working as part of law exams, around 10 editors. Currently we have selected from number of applications we got. They are already working with us along with law exams and also with LJRF. They are attending these sessions. My greetings to all of them. And also, we have supervisors who are faculties of various colleges of Kerala and also India, or researchers in various colleges in India. And also ultimately, we have resource persons who are experienced and expertise in particular areas of law for which we are going to give classes. LJRF is not just a paper organization. We always examine and critically analyze our plannings and dreams are useful for the society and fruitful for everyone. I have only just one guarantee, only just one word for all of you who are going to join with LJRF and who are going to be a part of LJRF district chapter of Ernakulam. Your efforts and your time that which you are going to spend for this organization, that will not be go in vain, that will always be fruitful and meaningful, and that will always makes you more strengthened and more useful person, more useful lawyer for this society. Wishing you all the best. Thank you.
Thank you everyone for listening the presentation made by Sri Jino Ankurian, who is the course director of LJRF Academy. And I now give it back to Sri Advocate Visruth Ravindran, who is the Vice President of Law and Justice Research Foundation. Back to you, Uttara. Thank you.
Thank you so much, sir, both Sandeep sir and Jino sir. The presentation that it really contained everything that LJRF was. It was really a great depiction of LJRF. Thank you both of you for your kind words and presentation. I now invite Advocate Visruth RS, Vice President LJRF State Chapter, for his presentation.
Thank you, Uttara. Am I audible?
Yes, sir, you're audible.
Without wasting much of your time, I guess it's better I move on to my presentation regarding the working of Trivandrum chapter of Law and Justice Research Foundation. The Trivandrum chapter was constituted on 6th September 2020. And at the time of its constitution, we had around 8 to 10 participants, which has now grown to a much larger number. And since the time of its inception, since the time of the launch of Trivandrum chapter, we have conducted a lot many activities in various fields, including a couple of webinars and classes and lectures on various nuances of law, which includes the arbitration law and international law as well. So to start with, the first interviewer of the Trivandrum chapter of LJRF was conducted on October 2nd, I should say, as a webinar on the occasion of Gandhi Jayanti, which we did in association with the District Legal Services Authority, Trivandrum, and the Constitutional Literacy Center, Cherayinkizhu, constituted under the Constituent Assembly of the Honorable Deputy Speaker of Kerala. And apart from the same, we have conducted a couple of other webinars on the November 1st and also on December 10th on Human Rights Day. And the webinar that the Trivandrum chapter conducted on December 10th was in connection with the Dr. B.R. Ambedkar Memorial Lecture Series. The lecture series is intended to have the legal luminaries interact with the young, vibrant minds in the legal education field in various nuances of law on the auspicious occasions which are very important in the legal fraternity to the state and the country. So based on the same, we have planned to conduct the lecture series on the December 10th on the Human Rights Day. And that was the day chosen for the inauguration of the Memorial Lecture Series. And the second lecture would be conducted on Jan 26th, which would be the Republic Day. And the third lecture would be carried around April 14th in connection with the Ambedkar Jayanti, and on August 15th in connection with the Independence Day. And the final lecture of the Dr. B.R. Ambedkar Memorial Lecture Series would be conducted on, I should say it's on November 26th, the National Law Day. So these are the initiatives that we have dealt with, along with certain other particular matters. And in connection with the Cochin Institute of International Arbitration, the Trivandrum LJRF chapter, we have organized a lot many arbitration classes. In fact, that also goes along like a series, because we have the arbitration classes been conducting on every Saturday since the time of the first class. It's been like around 10 classes till now, and we have got the experts in the field of international and national arbitration giving lectures and having a very interactive discussion. And I should say that like the Trivandrum chapter is proud about the fact that the participation in such activities has surmounted to such an extent that even we didn't expect this much of the law students, and that too from the first and second year along with the final years being participating here. So it's been quite an interesting initiative. And I should also tell you about the Criminal Justice Reforms Committee that is under process. We are planning to constitute a Criminal Justice Reforms Committee, which will be working on the law of probation. And we intend to develop a research team. In fact, we have got the list prepared for the volunteers who are ready to work with us in the research team for this law of probation Criminal Justice Reforms Committee. The same committee will be headed by a former district judge, and it will also be supervised by Dr. G. Mohan Gopal sir, the former director, National Judicial Academy and former vice chancellor, NLSIU Bangalore. Along with him, we also have this 5 senior faculties from the various government law colleges in Kerala assisting the whole team in conducting researches regarding the law of probation. So apart from all these activities, right now the participation in the Trivandrum chapter, I should mention that it has grown from 8 in the initial case to 80 participants in the right now at this moment when I am speaking. And I should say that along with this, that out of this 80 participants, around 30 to 40 participants are very active members in the group who are indulged in many activities that the Trivandrum chapter has been initiating. And the rest of the details, then the future programs will be updated to you, all of you, through our website. And that's all for today. Thank you. And I expect the same sort of cooperation to the future endeavors of LJRF. And also, I extend my sincere support and appreciation to the new list of office bearers for the LJRF Ernakulam chapter. Thank you. Over to you, Uttara.
Thank you so much, sir. Team together, everyone achieves more. No venture is successful unless it is in safe hands. To officially announce the office bearers of the LJRF Ernakulam chapter, I now invite Advocate Ajay R. Kamath, Secretary LJRF, for the announcement. I welcome you, sir.
Thank you, Uttara. I'm so proud to announce the office bearers of the Ernakulam chapter. I Advocate Vimal Kumar as the President, Advocate Indira A.V. as Vice President, Jijo Anthony, Assistant Professor, Bharat Mata College as Secretary, Sharin K. Nasser, Faculty, Al-Azhar Law College, Todupuzha as Joint Secretary, Srimati Chitra, Assistant Professor, Suvidha University as Joint Secretary, and Sri Rinsi Matthew, Research Scholar, Nuals as Treasurer. Thank you.
Thank you so much, sir. Hearty congratulations to all the newly elected office bearers. And I now invite the newly elected President, Advocate Vimal Kumar sir, to speak a few words. Hello, sir.
Hello.
Yes, sir, we can hear you. We can hear you, sir.
Okay. LJRFന്റെ ഒരു ഭാഗമായിട്ട് അധികം കാലമായിട്ടില്ല. എൻ്റെ പേര് വിമൽ. ഞാൻ 18 വർഷമായിട്ട് ഹൈക്കോടതിയിൽ പ്രാക്ടീസ് ചെയ്യുന്നു. LJRFും ഞാനുമായിട്ടുള്ളൊരു ബന്ധം എന്താണെന്ന് വെച്ച് കഴിഞ്ഞാൽ നിങ്ങളുടെ ഫൗണ്ടറായ സഫി മോഹൻ സാറിൻ്റെ ക്ലാസ്മേറ്റ് ആണ് ഞാൻ. അഡ്വൈസർ രാജേഷിൻ്റെയൊക്കെ ക്ലാസ്മേറ്റ് ആണ്. ഞാൻ പൊതുരംഗത്ത് ഈ രംഗത്ത് വർക്ക് ചെയ്യുന്ന പറഞ്ഞാൽ ലോയേഴ്സ് എൻവയൺമെന്റൽ അവയർനെസ് ഫോറം ലീഫ്, ഹൈക്കോടതി അഭിഭാഷകരുടെ അഭിഭാഷ അസോസിയേഷന്റെ ഗ്രീൻ സംഘടനയാണ് അതിൻ്റെ ഓഫീസ് ബെയറായിരുന്നു. കേരള പോലീസ് അക്കാഡമിയിലെ ഗസ്റ്റ് അധ്യാപകനാണ്. കുറച്ച് ടീച്ചിങ്ങും കുറച്ച് പ്രാക്ടീസും ഒക്കെ ആയിട്ട് അങ്ങനെ പോവുകയാണ്. അപ്പോഴാണ് എനിക്ക് പുതിയൊരു ഉത്തരവാദിത്വം നമ്മുടെ സഫി മോഹൻ സാറ് എന്നെ ഏൽപ്പിച്ചത്. എനിക്ക് ഏറ്റവും ആശ്ചര്യകരമായ കാര്യം എന്താണെന്ന് വെച്ചാൽ, ഇന്ന് ഞാൻ നമ്മുടെ എറണാകുളം ബാർ അസോസിയേഷൻ പ്രസിഡന്റ് PT ജോസ് സാറിനെ വിളിച്ചപ്പോൾ ജോസ് സാർ എൻ്റെ അടുത്ത് പറഞ്ഞു, നമുക്ക് ബാർ അസോസിയേഷനുമായിട്ട് കണക്ട് ചെയ്തിട്ട് ഒരുപാട് പരിപാടികൾ ചെയ്യണം. അത് ഒരു വലിയ പ്രചോദനമായി. അപ്പം അതിൻ്റെ കൂടെ ഒത്തിരി പരിപാടികൾ ചെയ്യാൻ പറ്റുന്നൊരു വിശ്വാസമുണ്ട്. അതുകൂടാണ്ട് എറണാകുളം ചാപ്റ്റർ ഇത് ഒരു വലിയൊരു ഉത്തരവാദിത്വമാണ് എൻ്റെ തലയിൽ ഏൽപ്പിച്ചത്. അപ്പോൾ എനിക്ക് അതിൻ്റെ സീരിയസ്നെസ് അറിയാം. കൊച്ചിൻ ചാപ്റ്റർ നമ്മൾ ഉഷാറായിട്ട് കൊണ്ടുപോകണം എന്നാണ് ആഗ്രഹം. പിന്നെ എൻ്റെ കൂടെ ഇന്ദിര മാഡം ഉണ്ട്, പിന്നെ ചിത്രയുണ്ട്, റൺസി ഉണ്ട്, പിന്നെ ജിജോ ഉണ്ട്. ഒരു നല്ല ടീമിനെയാണ് നമുക്കിവിടെ കിട്ടിയിരിക്കുന്നത്. ഇതൊരു വളരെ വലിയൊരു ഉത്തരവാദിത്വം ആണെന്ന് എനിക്കറിയാം. അപ്പോൾ എന്നെ ഏൽപ്പിച്ച സഫി സാറിനോട് നന്ദി പറയുന്നു, നിങ്ങളെല്ലാവരോടും നന്ദി പറയുന്നു. ഒരു കാര്യമുള്ളതെന്ന് പറഞ്ഞാൽ, ഞാൻ എൻ്റെ ഗുരുവും സീനിയറുമാണ് നാഗരാജ് സാർ. വളരെ അഭിമാനപുരസ്കരം പറയാവുന്നൊരു കാര്യം എന്ന് വെച്ചാൽ, എൻ്റെ സാറാണ് 3 കൊല്ലം LLBക്ക് ലോ അക്കാഡമിയിൽ. അതുകൂടാതെ കഴിഞ്ഞ 17 വർഷം ഞാൻ സാറിൻ്റെ ജൂനിയറായിരുന്നു. അതും വളരെ സന്തോഷമുള്ള കാര്യമായിട്ട് ഞാൻ നിങ്ങളടുത്ത് പറയും. അപ്പോൾ കൊച്ചിൻ ചാപ്റ്റർ വളരെ വിജയകരമായി പോകട്ടെ എന്ന് ആശംസിക്കുന്നു. നന്ദി.
Thank you so much, sir. Up next, I invite Advocate Indira AV to speak a few words, the newly elected Vice President. I welcome you, ma'am.
Good evening, everybody. Glad to get honored by incorporating myself as a part of your great team in implementing your great ideas. And I assure you, as I discussed with all the office bearers yesterday and days before, that I'll be able to contribute my level best in your ventures. And as per my within the purview of my limitations, I'll be able to share with you whatever requirements the organization demands from my end to uphold the strategy of work, and for the purpose of encouraging the upcoming legal fraternity in their ventures. That's all I would like to say. Thank you. Thank you.
Thank you so much, ma'am. I also invite Jijo Anthony, Assistant Professor, Bharat Mada Law College, the newly elected Secretary of Ernakulam Chapter, to speak a few words.
Thank you, Uttara. Good evening, respected dignitaries, my dear fellow members and dear participants. Myself, Jijo Anthony. I'm a law teacher. And in fact, it's a pleasure to work with the Law and Justice Research Foundation in the Ernakulam. In fact, we take it as a responsibility as well as a challenge to meet our vision and mission of LJRF. In fact, we are proposing several lecture series as well as several training programs, and thereby implement the constitution as well as the legal literacy among public. So ultimately, the beneficiaries are the public at large. So I extend my wholehearted thanks to all, and I expect all kind of support from the LJRF family. So I once again thank you.
Thank you so much, sir. Now we have come to an end. Nothing is complete without a thanksgiving. For that, I now invite Ms. Rosemary Sibi, member LJRF State Chapter and also Secretary, LJRF Trivandrum Chapter, to deliver the vote of thanks. I welcome you, ma'am.
Thank you. I will spread my wings and I will learn how to fly. I will do that until it touches the sky. Yes, here LJRF, the team LJRF has again radiated our light to the tune of Arabian Sea. That is our one and only Cochin. Yes, today we have done with our Ernakulam chapter inauguration. So I would like to take this opportunity for thanking all who made this occasion really auspicious. First of all, our LJRF's dear president who presided this function, Advocate Tejas Purushothaman. Sir, he always been a caring guardian for the entire team LJRF. So this time also, he made a warm presidential address. Thanks to you, sir. A heartfelt thanks to you, sir. Now, then I would like to thank Advocate K.P. Jayachandran, Chairman Bar Council of Kerala, who inaugurated this function. He is a mentor of LJRF and he finds time to spare for us, irrespective of his busy schedule. Thank you so much, sir, for being part of this occasion. Then Advocate Nagaraj Narayan, Member Bar Council of Kerala, who gave an enlightening speech on Constitution after Keshavananda Bharati judgment. Sir actually gave a clear idea about the said topic and he covered various aspects of the same topic. Thank you so much, sir. We are really honored to have you with us today. Then I would like to thank Advocate R. Lakshmi Narayan, President Kerala High Court Advocates Association, then Advocate P.T. Jose, President Ernakulam Bar Association, then Advocate Johnson Gomez, Director, Cochin Institute of International Arbitration. We are extremely grateful to these three charming personalities. Thank you. I have a special guest, Saroja ma'am, former principal of various law colleges. Ma'am, actually we are extremely happy to have you with us for your participation. Thank you so much. And now the four vital organs of team LJRF. Advocate Ajay R. Kamath, the Secretary, Advocate Sandeep Chandrasekhar, Joint Secretary, Advocate Visruth R.S., Vice President, and then Advocate Gino M. Kudian, LJRF Academy's Course Director. Actually, without these not move this much fast. Our team LJRF's backbone are these four persons. Thank you so much. Heartfelt thankfulness to you four. Now, along with my thanks, I would like to congratulate the new office bearers of Ernakulam chapter, especially those who spoke here, Vimal Kumar sir and Indra ma'am and Judicial Anthony. Thank you so much. Finally, the entire LJRF team and dear participants, heartfelt thanks to you all. Thanks once again, and Jai Hind. Over to you, Uttara. Thank you.
Thank you so much. Thank you so much, ma'am. Let's give a moment of respect to our national anthem.
Nayak Jaya Hind. भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Congratulating and wishing all the Ernakulam chapter members all the best. And I now declare that today's program officially over. Wishing everyone a safe and happy Christmas and a happy New Year. Jai Hind.